Hi, Nan Jensen here. This is video number 4 in the Preparing for Adulthood series about welfare guardianship. My disclaimer first, the information in these videos is only information, it's not advice. Do not rely on anything you hear in the videos. If you need legal advice, you need to see a lawyer or talk to a lawyer. You need to give them your full situation and you need to get a letter of engagement from them. Okay, so the topic today is welfare guardianship. The last video was about guardianship, which had to do with children, and so the welfare guardianship is what kicks in if an adult does not have capacity. So guardianship was about children who are not considered to have capacity. Welfare guardianship is under the Protection of Personal and Property Rights Act, which we talked about in video 1 and 2, I believe. So now we're back to talking about that act again. Welfare guardians are appointed under this act. They're appointed by the family court. And to become a welfare guardian, it involves an application to the family court. Now, I think I mentioned that these applications do not cost anything if you make the application yourself. I mean, there's no filing fee, but there is a process involved, and I'm going to describe the process for you in a minute. First of all, there's been a recent law change. It used to be that there could only be one welfare guardian, and that was a bit upsetting to parents who had shared the care of their disabled child for years and then went to apply as adults and found out when the person was an adult and found out that they could, only one of them could be appointed. It was always the case that two could be appointed in exceptional circumstances, but that wasn't always easy to prove. Now the law has been changed so that two welfare guardians could be appointed if it's in the best interests of the subject person. So that's an easier threshold to get over, and so that means that parents who have been looking after their child until they became an adult now can continue in the guardianship role together. I need to note, though, that guardianship will always be joint unless specified otherwise, and joint does mean that both people need to be there to sign everything and to make decisions. Now, I'm not sure that the people they're telling the decision about will actually know that, but legally that's the situation. So that can be a little bit of a complication if you do choose and get appointed as joint guardians. Guardianship, the first application lasts for 3 years, or maximum of 3 years. The judge can decide to make it for a shorter time if they choose. Why would they choose it? Might be that there's some sort of dispute and they just want to check and make sure it's all going to go okay, so they want to review it in a shorter period of time to make sure everything's okay. But generally 3 years is the norm, and it is the maximum for the first application. Now, people may say to themselves, well, I've been looking after my child all these 18 years. Why is the court suddenly interfering after 3 years when nobody questioned for 18 years? Well, the reason is that welfare guardianship and guardianship are not the same. As a guardian, you're looking after a child. As a welfare guardian, you're looking after an adult. Adults have rights, and those rights have to be respected. And as a welfare guardian, you have a number of responsibilities that you didn't have as a guardian, and we talked about some of them in, I think it was in videos 1 or 2. And so the purpose of the 3-year review, at least after the first order, is to ensure that those the person's rights are being upheld, that they still need a welfare guardian because sometimes people's condition improves and they develop some capacity. So there are a number of reasons why a review is a good idea. After the first order, you can apply. You need to reapply if you're going to reapply. And then it can be a 5-year order. It used to be that 5-year orders were only made with exceptional circumstances proven. Now the bar has been lowered, or the threshold has been lowered, so now 5 years is more or less the norm, unless the court thinks a shorter period is appropriate. So again, a lot of discretion goes to the judge. Okay, so those are the main things about welfare guardianship. Now here's the process. Whoever wants to make the application, and that isn't necessarily the person wanting to be appointed, but let's say it's a mother or a father, they can download some paperwork from the Ministry of Justice website, and I'll put a link to that on the Facebook page and in the notes to the YouTube, on the YouTube page. They can download those and make the application themselves, or they can hire a lawyer to do the application for them. Obviously, if you hire a lawyer, it's going to cost money. If you do it yourself, then you need to download those forms and get everything filled in. There's no filing fee. This is the last family court application, aside from domestic violence things, that don't have filing fees. So in terms of that, there's no cost. And if you have you don't use a lawyer, then there's no cost. But one of the things that happens is that a lawyer will be appointed for your disabled person, and the court has the power to direct you to pay that person's costs. I'll talk a little bit more about that in a minute. So the forms include an affidavit, which is a fancy name for a statement, a sworn statement or an affirmed statement. There's a whole bunch of consents and an application form, an information sheet, a bunch of different papers like that. And then there's also a medical form that needs to be filled in by the doctor. And I can't really say what kind of doctor. It really depends on the person's condition. If it's a borderline case and we're not sure if the person has capacity or not, then it could involve a specialist. If the person is severely disabled and they've been that way since birth and the doctor has known them all their lives, then it's probably going to be fine with a medical form from the GP. But again, that's going to be up to the court. Every case is handled individually. So once all the forms are ready, a number of them have to be witnessed or sworn in front of a JP or a solicitor or a court registrar. Then you go down to the court and you file it. And filing it is a fancy word for saying you hand it to the registrar. And once that application is with the registrar, then the process gets started. So a lawyer gets appointed for the subject person. And if you are using a lawyer to make the application, then you need to understand that the lawyer you hired is your lawyer, but the lawyer appointed for your disabled person or your subject person is their lawyer, and that lawyer is independent. And the idea with that is to make sure there's no conflicts of interest and that they're properly and independently represented. So that lawyer will contact you and meet with the subject person. They will write a report for the court that covers a number of different questions. I won't go into all those details, but one of them is whether you're the appropriate person to be appointed if you've applied for yourself to be appointed. And then that report goes to the court. Now, if it's a routine application and there are no complications, which we'll talk about in a minute, then the file normally goes straight to a judge, and the judge will make a decision on the papers. And on the papers means that the judge sits in his or her office and makes a decision, and you are then informed and sent copies of the sealed orders. Now, complications. What complications can arise? Well, if you are parents of a disabled person and you don't agree about who's going to be the welfare guardian, then that could be an issue. Sometimes one parent makes the application and doesn't inform the other, or doesn't try to get their consent. That's not a really good idea. And if there is a dispute like that, or a potential dispute, then it's a good idea to use a lawyer because there's likely to be a hearing and other sorts of court appearances that you may need assistance with. It's not necessary, but it's probably a good idea. Not a good idea to not tell them about the other spouse or other parent, because the court will find out and that won't look good for you. Now, if you're the applicant, you aren't necessarily the appointee. The applicant can apply for other people to be appointed, for the same person, or to be appointed both welfare guardian and property, or different people for both. So, or you can also apply for yourself to be appointed to both. So just want to point out that the applicant is not necessarily the appointee. The process for reapplication is very similar, same forms, it's just that you're possibly going to request something different because it's a second time around. Now these obviously aren't just for people who were born with a disability and continue to be disabled. People have accidents and become disabled, elderly people get dementia or have other medical conditions that might require them to have a welfare guardian appointed. And one really important thing that we're going to talk about is powers of attorney, because you give power of attorney when you have capacity, and what you need to realize is that if you haven't done these, then someone may have to apply to be your welfare guardian at some point. So this is one of the reasons I say all the topics are connected, and we'll talk about powers of attorney later. But I just think it's important to point out that these things are linked together, and that anybody could wind up needing a welfare guardian if they haven't put their legal affairs in order. So I'm saying this not because I want to make money as a lawyer or I want to help other lawyers make money. It's because there's certain things that just are really good to have in place legally to make things easier for your family. Okay, so that's the end of video number 4. It looks like it's been a long one. I'll see you in the next video.